A non-governmental organization, civil society organization, had a press briefing on the conviction of Maryam Sanda'S held at the Secretariat of Nigerian Union of Journalists in Abuja. The briefing was aimed at addressing the case of Maryam Sanda'S, who was sentenced to death by hanging on Monday, the 27th of January 2020 by Justice Yusuf Halelu. The national coordinator of the organization, Emmanuel Onwubike, said the accused was judged based on circumstantial evidence that there were no eyewitnesses to prove that the accused murdered her husband.
Our task as human rights promoters is to ensure that no life is taken unjustifiably. Section 33, subsection 1 is quite clear on the right to life.
It is the law of this nation that the charge of murder or culpable homicide must be proven beyond reasonable doubt. We feel that it is curious why a judge would trifle with an offense of culpable homicide, which attracts the death penalty, by choosing to draw conclusions of guilt of Maryam based on hearsay. We must point out that no witness testified to seeing Maryam stabbing her husband. No murder weapon was tendered by the police in evidence. No confessional statement was made by Maryam or anyone else for that matter. And no two of the 6 police witnesses corroborated each other's testimonies to the effect that Maryam killed her husband.
Advocacy leader of Society for Civil Education and Gender Equity, in her speech said the law should have considered the children of both Bilyaminu and Maryam before concluding on such judgment, that in the eyes of the law it is known to be double jeopardy.
2 little kids of Maryam and Aminu, both under 2 years. All we think of is in the doctrine of double jeopardy. We know that in our law, double jeopardy is prohibited. The kids have lost their father in an unfortunate circumstances. Should they lose their mother too? Can we think about these kids for a moment? We appeal to our common humanity. Let's put these children first in our consideration.
Zuwaira Hamza, TVN News.